Good afternoon, sir, and good afternoon, everyone. I'd like to thank you all for taking the time to attend this webinar session. As you all may be aware, this is the Nyaya webinar series on practical skills in litigation. The Nyaya forum was started around 5 years ago, and it's a student-run initiative to promote courtroom lawyering or litigation among students in law schools. And this is our series to promote practical skills. Now, a little about hello, am I audible? Hello.
You're audible to me.
Right. All right. So a little about Mr. R. Basant. Mr. R. Basant is a designated senior advocate at the Supreme Court. Designated in 2012. Before which he was also appointed as a permanent judge of the High Court of Kerala. Mr. Basant was elevated to the High Court from the districts and sessions court. He has had a long and sterling career in criminal law, having been involved in criminal cases from both sides as a judge as well as a lawyer. Mr. Basant is best placed to tell us about how the various aspects of criminal law work. Without further ado, I would like to turn the session over to Mr. Basant and invite Mr. Basant to speak.
Thank you, Nirupam. Am I audible? Is that right? I can't get anything on my screen. There is some glitch.
Yes, sir, you're audible.
On my screen. I'm audible. Huh? I can go ahead now.
Yes, sir, you can go ahead. Thanks.
Very. A very good evening to all the participants. Thank you, Nyaya Forum, for organizing this webinar. I mean, the young lawyers are thinking of courtroom lawyering. The pandemic has changed the world entirely, and I think it's going to change the legal system or the details of functioning of the legal system. So Nyaya Forum for courtroom lawyering, I don't know how much of it will be left after the pandemic, after the lockdowns. How much of the courtroom lawyering will be there? In any case, I think it could be considerably changed. The courtroom lawyering could be considerably changed after we emerge out of the pandemic. Now it's good that young lawyers to be are trying to use their time most usefully, even during the lockdown and the rigors of the pandemic, and then decided to spend time to know more about courtroom lawyering, the skills of courtroom lawyering. Well, you acquired skills as you pass by, and I find there's a great disadvantage of living too long. And what that is, every experience that you have is a repetition of the previous one. You don't get very many first experiences as you grow older. But today, you have given me an opportunity, because this is the first webinar that I'm attending, and I'm certain that it's going to be, I'll remember it all along. Well, a webinar is very different from a seminar, as perhaps the video conferencing courses are going to be for you young lawyers to be. A lot of lawyering, a lot of speaking, a lot of engaging in a class depends upon the responses that you get from the participants. I think tomorrow's code, you may not get that response in video conference. How well you'll be able to read the twinkle in the eye part to decide whether he's agreeing with you or not. These qualities, these are going to be difficult in future. And similarly, sitting here and doing a webinar, in a seminar, in a classroom, you get a lot of return by the twinkling of the eyes of the participants, whether they are following, whether they're not following. But today, I have to do it without any input that way. Very good. Let me try my best. This first experience of mine. Well, what to me is important, perhaps, is that today's function, today's initiative is also part of a larger scheme, a constitutional scheme, perhaps. You all know that in the Chapter 4A of the Indian Constitution, it was not there in 1950 when we gave unto ourselves the Constitution, but later we find in 1977, during what they call the dark days of Indian constitutional history and democratic history, you find this chapter finding its way into the Constitution. This chapter on fundamental duties of the Indian citizen. At a certain time when it was enacted, we gave unto ourselves the Constitution, we perhaps did not think it necessary. But in 1977, we got this Chapter 4A introduced, and it's just a one article chapter, 51A, Article 51A. There are as many as 11 duties, fundamental duties for the Indian citizen. But maybe we are interested only in duty number 10, that is 51AJ. And 51AJ says that it shall be the duty of every Indian citizen to strive towards excellence in all spheres of individual and collective activity, so that the nation rises constantly to higher levels of endeavor and achievement. Duty in the concept. I particularly like that portion which says endeavor and achievement. We are all endeavoring for perfection. We are all supposed to. Everyone in this country has a constitutional duty to strive towards excellence. Now, I have a long, as the one who introduced told you, I have a long period of interaction with the system. I think it's about 5 decades after I started interacting with the system. 3 years initially as a law student like you, then the next 15 years as a trial court lawyer with very, very occasional visits to the High Court. And 15 years as a district session judge, where you practically come across every court. In the last, I can vouch say that this chip of strive for excellence is badly lacking in the Indian computer to the Indian mind. The strive for excellence, walk through the corridors of our courts, from the apex court down to the lowest court, you find the strive for excellence singularly lacking. In some places that exception we find that, but then generally I find there is no strive for excellence. And this means, and because of this, you will find the strive for excellence has to be cultivated, and that is where I compliment and congratulate Nyaya for having organized this function at a time when the college is closed. What is strive for excellence? It is not simple. Strive for excellence is not unidimensional. It is not merely an attempt to advance you in your professional skills alone. I believe it must also necessarily include the strive for ethical excellence. We ought to strive for ethical excellence also. Well, first of all, let me ask you, you all, I find you want to do court lawyering, and then what you're all trying to join a profession, the noble profession of law, you all want to join. What is a profession vis-a-vis an ordinary career? How is a profession different from a career? I would always say that profession is career plus something. What is that plus? Career plus something. What is that career plus? I want young lawyers to be very, very sure of this. I want them to understand the distinction between a mere career and a profession. Well, today, surprisingly, I hear at a certain point of time, it was assumed that at least the legal profession and the medical profession were outstanding examples of professions where there are elements of a career and service. But today I find the doctor is often referred to as a worker in the healthcare industry. Now, yesterday I came across this somewhere, that we are all functionaries of the legal industry. Well, I'm shocked, I'm perturbed, I'm worried. Well, I don't want the young lawyers to think that they are just functionaries or the workers or the legal industry. Far from that. I believe in order to become a lawyer, you ought to have a commitment to the fact that you belong to a profession of law. A profession of law which is not merely a career, it is career plus service to the people. Well, all of you appear to have thought that a career in law, a career as a criminal lawyer is what perhaps attracts you, and that is why I've been told by Justice Nagamuthu, Justice Madam Rebecca, that you have had classes on the trial part of it. And today they wanted me, the caption is appreciation of evidence, something about the advocacy part of it, and then the appreciation of evidence, of course. Criminal lawyer, because it's very, very wrongly understood. A criminal lawyer is not a lawyer who's a criminal, is the one who's on the criminal side, though we often refer to him as the ethical conflicts, worries, the anxieties. Generally, it is assumed that the criminal lawyer makes money by defending criminals. He facilitates the commission of the crime by defending criminals, by lending his faculties, sharp faculties to the criminals. He gets criminals out of punishment, and therefore it is said that the criminal lawyer is just a one aiding and assisting a criminal. I find this conflict in the minds of many a young criminal lawyer. He always worries, what am I? What is my position? What is my ethical commitment? How am I to go at my work without compromising my idealism, my commitment to larger values in life? Now, this is the problem which a criminal lawyer always has. Well, I know it's not only for the layman, and I hear laymen usually remarking that the lawyers are liars and a criminal lawyer lives on crime and things like that. I would not have worried about that, such a comment from the layman. But today I find sometimes even the lawyer community says, don't appear for so-and-so because he's a criminal. He's a very bad criminal. He has committed a very bad offense. Therefore, don't appear for him. Well, I had the shock of my life when I appeared in a criminal case before the Supreme Court, and the judge asked, this is not a case in which people like you, retired judges and senior counsel can appear. Well, the point is the criminal lawyers are misunderstood to be mercenaries of a criminal. Mercenaries of criminal. We are not. I think it's important that the young lawyers to be realized that we are not in any way mercenaries of criminals. Well, the criminal law has its foundation in defending freedom and liberty. Freedom and liberty and the civilizational fineness of the legal system is often protected in the criminal courts. Well, you all know, I need not tell you, some of the axioms of the fineness of the justice system, criminal justice system in this country is that no one shall be punished unheard. Well, one of the fundamental. Every procedural safeguards have to be observed before a person is deprived of life and liberty. Every person accused of a crime who faces the prospect of deprivation of life and liberty is entitled to legal assistance. Every person, before he is deprived of liberty, must have his culpability. These are fundamentals and foundations. He is not a mercenary for criminal, but on the contrary, he is the warrior for liberty and freedom. He is the warrior for the civilizational fineness of the system. Well, once you have this very clear in your mind as to what you are and what you're supposed to do, I think the ethical the ethical excellence which you're striving for will be very clear in your mind. Young lawyers should not think that we are mercenaries for criminals, but we are defenders of freedom and liberty. We are defenders of the constitutional fineness. We are defenders of the fine constitutional principles. Let me call it. It has often been said that the war for the liberty and freedom, liberty and independence are so dear that sometimes you may have to share your foxholes with criminals, bootleggers, murderers, all that you'll have to do. But do not for a moment forget that you are not fighting the battle for any one of these particularly. We are really fighting a battle royal for civilizational principles of freedom, liberty, and procedural fineness. Well, once that is very clearly understood, I think we can get on to our work of appreciation of evidence we are talking. How you look at your duty, criminal lawyer, to understand every aspiring criminal lawyer to understand that we are not mercenaries for the criminals. We are defenders of freedom, liberty, and the constitutional fineness. Right? You have been taken through. I find you've been taken through perhaps all the various aspects of a criminal trial, starting from investigation, a registration of FIR, commencement of investigation, further investigation, filing of final report or charge sheet, framing of charges, the trial and the evidence, what is evidence, what is not evidence, which evidence is admissible, which evidence is inadmissible, what evidence is relevant, what is not relevant. I'm not going to touch upon all that today. You have already been apprised of is what I've been told, and then I'll come to perhaps the last stage. Even after 313 statements are recorded, we find the lawyer addressing the court and requesting the court to look at all the matters before it and come to appropriate conclusions. Well, this I would call is the limited area of what we refer to as appreciation of evidence. What is the law relating to appreciation of evidence? What is the rule relating to appreciation of evidence? Where do I locate it? I always remember a great judge of the Kerala High Court, Justice U.L. Bhatt, used to say, the only rule in appreciation of evidence is that there is no rule at all. There is no rule. There is no rule relating to appreciation of evidence. But then how do you do it? In a country wedded to rule of law, in a system wedded to rule of law, you can't have appreciation of evidence as you want. There must be some rules or the procedures regarding appreciation of evidence. Well, if you search and find out, you will understand that law defines what is relevant, what law relating to relevancy, law relating to admissibility, law relating to the manner of proof, law relating to questioning the accused on the materials that are available. But as far as appreciation of evidence is concerned, I have to tell you that there is no specific provision relating to appreciation of evidence. But then where do I locate it? I would say that our search for a provision of law would take us ultimately to Section 3 of the Evidence Act. Section 3 of the Evidence Act, I would say, is the Bible regarding appreciation of evidence. Appreciation of evidence depends upon the Section 3 of the Evidence Act, which defines three different expressions. Those expressions are expression proved, expression disproved, and expression not proved. All these three. I would think that any criminal lawyer, any trial judge, any judge dealing with criminal in the criminal law, the criminal trial, must learn this expression by heart as to what is the meaning of the expression proved, disproved, and not proved. And the great advantage is, if you study one, you will get all the other two. And therefore, you need worry only about the first expression. What does the expression proved mean? Now, appreciation of evidence, you have a lot of material. You have, as I told you, you have evidence or oral, documentary, you have ocular evidence, eyewitness evidence, you have circumstantial evidence, you have confessions, you have admissions. All these are there with you. And all these are admissible evidence which should have come before court. There's a lot of admissible evidence which is available before the court. Now we have to proceed and find out what is the acceptable evidence. The distance between admissible evidence and acceptable evidence is the area of appreciation of evidence. One is to understand what all these, once you have mastered the Evidence Act, once you have mastered the procedure relating to trial and the 313 examination of an accused in a criminal case, you have all the materials before you. They are all materials. They are all materials which the court can act upon, accept, if the court is satisfied. Now, this is called appreciation of evidence. Of evidence is filling the full gamut of admissible evidence. I'm not talking about a case where inadmissible evidence has come in. No, not at all. I'm assuming that only the trial has been held very legally, conforming to all procedures of the Evidence Act, Code of Criminal Procedure. No, but still there is a distance between admissible evidence and acceptable evidence. And that whole distance is to be covered by the discretion of the trial judge. So now come back to Section 3. And what is Section 3? I think it's once you go through that, you'll find it really convey much also. It says, James Stephen, very, 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 shall I say, resourceful. He never tried to define the expression proved with reference to truth or correctness. He only said, when can a fact be said to be proved? Now, the first expression proved says, a fact is said to be all the matters before it, not the evidence alone, not the presumptions alone. After considering all the matters before it, the court considers it to exist, believes it to exist, to borrow the expression. When a court, after considering all the matters before it, believes it to exist, it is the first limb of the expression proved. Then that appreciation of evidence must lead to the conclusion that the court, the presiding judge, comes to the conclusion that the fact exists, believes it to exist. Now there is another limb. It says either the judge believes, the court believes it to exist, or considers its existence so probable that a prudent man, includes woman of course, prudent person, ought to proceed, look at it again, in the circumstance of the case, proceed on the supposition that the fact exists. Well, you understand? I'll repeat for you all. You must learn Section 3 by heart. Any criminal lawyer, any criminal judge, any student of criminal law relating to trial process and appreciation of evidence must understand Section 3 fully. The meaning of the word proved in Section 3. A fact is said to be proved when the court, considering all matters before it, believes it to exist. One, either he believes it to exist or considers its existence so probable that a prudent man, in the circumstance of the case, ought to proceed on the supposition that it exists. This is the meaning of the expression proved. And the quintessence of the law relating to appreciation of evidence, you will find in this expression, the definition of this expression proved. It is after considering this definition in Section 3 of the expression proved that you must start appreciation of evidence. What are your destinations? This has to be ascertained by correctly understanding the provisions of Section 3 of the evidence. Now, what is the expression disproved? A fact is said to be disproved, same definition, but only the mutandis changes. A fact is said to be disproved if the court, on considering all the matters before it, believes it not to exist. See the difference? Believes it not to exist, or considers its existence so improbable that a prudent man ought to proceed on the supposition that it does not exist. Right? I told you, if you know proved, not proved is very, very easy. I mean, disproved is very, very easy. So you now have proved, you are now disproved. At one end of the scenario, you have the facts that are proved. On the other end, you have the second category of cases which are held to be disproved. Now, in between, you still have. It's a long line. One end is proved, the other end is disproved. Other segment, the last one is comes with the sweep of the expression not proved. So that a person claiming a relief has to come and say that I come under I have proved my case. And the appreciation of evidence must lead the court to the conclusion that this is neither disproved nor not proved. It must belong to the category of proved, facts that are proved. The appreciation of evidence must lead the court to one of these three conclusions. Either it is proved, or it is not proved, or it is disproved, or in between it is not proved. Well, this is the soul of the Indian law relating to appreciation of evidence. I believe the expression borrows a lot from, first, a court believes it to exist. Either the two limbs, either this or this. I don't think the latter part is an explanation to the first part, because the expression either or clearly shows they are disjunctive, they're two different things. The latter is not explaining the former expression, and therefore where the court with its experience, with its sixth sense, with its trained intuitions, come to the conclusion that it believes a fact to exist, that is proved. And the court considers it to be so probable that a prudent mind ought to proceed on the supposition that it exists, it against. Therefore, at any time when the court starts appreciation of evidence after the entire trial, the last part of the trial, maybe the penultimate part. Today, sentencing is also very important. So if I say the last part of the trial, it may not be correct. It includes the imposition of the appropriate punishment, and therefore the last segment in a trial would be the imposition of the punishment or the whatever. I shall say, the consequence of the crime should be the last part. The penultimate part is about the decision as to whether the allegations are proved or not. And in doing this, I find there's a lot of elements of subjectivity also. As soon as you borrow the expression prudent man, and a court tries to sit in the armchair of the prudent man and try to decide a question, there is bound to be disagreements. What a prudent person would do may not always, it may not be a monolith. You cannot specifically identify it to be coming within that category. What circumstances would a prudent man consider the existence so probable and act on it? That's a question that the court is to decide. Well, when you read the definition of the expression proved, the soul or the quintessence of the law relating to appreciation of evidence, you will also find there's a very interesting situation. Now, at a time when the jury trial was there, it was much easier for the judge. You know, in India, various parts there was jury trial. In the US, it continues. In some other countries, they have dispensed with it. India has dispensed with jury trial altogether. But the definition relates to, Stephen's definition relates to a period when the jury trial was also there. I think it was very comfortable life for the judge at that point, of trial judge at that point of time. All that he does is he explains the ingredient. The judge explains the ingredients of the offense to the jury. The judge tells the jury, you take this evidence into consideration. You don't take this evidence into consideration because it is inadmissible. It is irrelevant. So you don't look into it at all. So it feeds the computer of the jury with the ingredients, the law relating to the ingredients of the offense, the admissible pieces of evidence, the exclusion of inadmissible pieces of evidence, and say, you decide. And the jury, living examples of 13 in many cases, in otherwise lesser number also, are living examples of prudent men in a community. And those prudent men and women, given all these facts, given all this, about the ingredients of the offense, he would decide that this person is guilty or not. So all this definition you will find the judge at that point of time had a much more comfortable, convenient life because the verdict came from the jury. Jury was to decide. Today's Indian judge has not only got to decide what are the ingredients of the offense, not only what are the admissible pieces of evidence, inadmissible pieces of evidence, but also come to the conclusion as to what is the verdict, the conclusion, whether the fact is being proved or not. So, it is important for lawyers to understand that at the end of the day, much would depend upon the assessment of a trial judge or of a criminal judge on the probabilities of the situation. There can be no hard and fast rule. I've often heard in some courts, oh, there are 4 eyewitnesses. Apart from it, the number of eyewitnesses does not decide anything. The probabilities of the matter would decide, yes, there are 4 eyewitnesses is a relevant fact. There are injured eyewitnesses is a relevant fact. But there is no litmus test to decide whether such persons are believable or not. That is why I would think that Section 3 says, ultimately before it ends, it also said, in the circumstance of the case, considers its existence so probable. Well, there are so many ifs and buts for this. What is important according to me is that the lawyer and the judge must realize the importance of appreciation. Well, you know Lord Atkins' decision which says, now a word of advocacy to the lawyers. Lord Atkins' famous dictum which said you can take up a defense of alibi and private defense at the same time. Yes, theoretically, yes. But all lawyers should always understand that they are dealing with living stuffs of men as judges. Living stuff of human beings as judges. Whatever may have been said, I remember my senior used to always say, if there is a possibility, you ought to build up a positive case of defense. Well, denying everything from the death of the deceased to your presence there in the locality may not be anathema to law, but then it is definitely anathema to the common sense or the living person appreciating the evidence. Well, I cannot give you, no one can ever give you the parameters as to what are the circumstances under which an eyewitness should be believed or not believed, or a circumstantial evidence witness can be believed or not believed, what importance is to be given to a witness, where to look for corroboration. These are all details regarding appreciation of evidence on which it is impossible for anyone at any point of time to lay down inflexible rules of appreciation of evidence. Appreciation of evidence to that extent must remain a little non-specific, non-rigid. It is only on consideration of the entire facts and circumstances that a court can come to an ultimate decision. And therefore, the trial lawyer, the criminal lawyer, should always remember, according to me, that it is very important that you have a very constructive case. Well, the way the trials are conducted, that again is a matter of grave concern. At the time when I started practice of law, that is in 1973, enrolled as a lawyer, the trial court had doyens of the bar, very strong, very, what shall I say, very authoritative, very authentic, commanding great moral authority and power over the society as trial lawyers. Well, days have changed, and the migration from the district to the High Court and or direct migration, even without following the steps of the trial court and the appellate court to the Supreme Court, is happening every day. But this leads to a problem in the that many of those and forum to impress upon your members the importance of spending at least a short period of time in the trial courts and the first appellate courts, which according to me is very important. For many reasons, you know, I have a son who's a lawyer, and then when he started practice, I insisted that you must spend some time in the trial court. Why? Well, I believe, this I tell all my juniors also, spend some time in the trial court so that you know how a case is born. How a case is born. What are the compulsions of a trial court lawyer? Why does he take up certain defenses? Why does he not take up some defenses? Today in the Supreme Court, you can hear judges and lawyers say, oh, that trial lawyer did not take up that defense. That was proved to be costly for the client, etc., etc. But it always understand that the case is born, the case is shaped, the case is built there, and therefore it's very important that you have a very good trial lawyer. At the trial level, it is handled very intelligently with resourcefulness, always having an eye on Section 3 of the Evidence Act, that I am ultimately to appeal to the sense of right and wrong of a trial judge. He is to assess probabilities. Though Lord Atkin might have said you can take up the defense of the private defense and the alibi at the same time, it would be, according to me, suicidal today, given the criminal law that we have, given the manner in which evidence is being appreciated, for any lawyer to take up a defense, such contradictory defenses. They are self-destructive, and I would advise all the trial lawyers to make sure that as far as possible, it is better to have a positive, constructive case for a defense. In the appreciation of evidence, that could go a long way in persuading a judge to accept your version. You ought to have a version. I'm not saying that like the pleadings in a civil case, an an accused should also. Well, but then totally contradictory defenses are likely to rub the judge who is appreciating the evidence on the wrong, and you are likely to land up in great difficulty at the end of the day. Only a practical. It's not on the law part of it might justify. In a very special case where elements of both these are available, maybe you try that also. But the run of the mill, the ordinary, if we start trying to say that I will take up all the available defenses, you ultimately get no defense at all. That's what's happening. Days are changing. It's important that you understand Section 3 of the you have read that. I don't wanted to multiply rulings. The decisions have even gone to the extent of saying where there is a ring of truth around the evidence of a witness, his evidence deserves to be looked into very carefully, even if it is a sole witness, even if he is the relative witness, even if he is an interested witness, you have to do that. And therefore, it is important that we take stock of the great distance that appreciation of evidence is covered by now. Well, if you read the judgments of some earlier years, say 3 or 4 decades back, the times when I started practice, you will perhaps be shocked that how could a court not believe hold that it is not proved in the circumstance. Days are changing, and it's therefore very important that young lawyers understand the importance of taking up a positive case, so that in the ultimate realm of appreciation of evidence, you would fare much better as a trial lawyer, as a criminal lawyer dealing with. Ultimately, what does the trial lawyer do? You are not ultimately judging. A good trial lawyer, a good lawyer is one who will take his judge to that seat from where, when you view this truth, the dimension of this truth appears to be most in your favor. I think ultimately all your cross-examination, all your arguments must be to take that reasonably prudent person, that prudent man, the judge, take him to a vantage point from where, if you look at facts, you will be able to show yourself in the best light that is possible. Well, there are reasonable doubt also on that. Well, that is perhaps the duty of a trial of a lawyer in the manner of appreciation of evidence. Always remember that truth is not unidimensional. For every problem, there is an angle from which, when you view it, probably you would appear to be justified. And the good trial lawyer's mission or his brief, his commitment must be to take his judge to that point and show him from that angle probably the best version that is available for him, and try to generate a reasonable doubt on what is available. Well, you have to understand that. We all have to, as trial lawyers, trial judges, we all have to understand that the appreciation of evidence is an art or a science which does not follow any specific rules. How A behaves in a given situation may not be the way in which B behaves in the given situation. So you can't afford A's standard of behavior as the litmus test to judge B's behavior. And therefore, it's important today that a lawyer understands this. Now, and also, I would also like to tell you in the appreciation of evidence today is very important. Now, earlier, you remember, there were days in my young days where we used to fashion our defense on the evidence that the prosecution wants to rely. We know pretty well that a certain piece of evidence is not relied on by the prosecution. If that were introduced into evidence, it would hurt the defense. But we know they have not relied upon that, and you try to build up a defense. Today, it becomes very difficult. The more frequent is a resort to Section 311 CRPC, 165 CRPC Evidence Act, that the judge, an alert, participating judge, always thinks that he should intervene, put questions, examine witnesses. So it's very important that before we shape the defense, we understand all the circumstances which may ultimately be introduced in evidence and might weigh with the court in the appreciation of evidence. The court, after considering all matters before it, all matters I've already told you is not only evidence, not only presumptions, not only 313 statements, even the demeanor of a witness might sometimes count. And therefore, that you have to understand that considering all matters before it. Well, the appreciation of evidence as an art or science is such that lawyers have to be careful about the defenses that they take and the possibility of viewing truth from various sides. I remember at the time when we started, the good cross-examiner was he who could bring out the maximum number of contradictions and omissions from a witness. He would say, oh, Mr. X cross-examined, got 25 contradictions from one witness. Oh, and then we thought the case was over. Well, today we understand that contradictions are irrelevant until they take a deviation of the original case of the prosecution in order to explain some insurmountable existing circumstances. A mere contradiction as to whether one turned left or right, we use the left hand or the right hand, or who came first, who came next. All these which were once upon a time very important are no more important in the appreciation of evidence now. Today, a contradiction qualifies to be a contradiction only if it is an attempt by the witness or the prosecution to get over an insurmountable fact and get out of it. Or a contradiction or an omission which does not qualify for this may not be relevant at all in the appreciation of evidence or the present times. You have got to understand. The courts are also realistic. Courts also know how difficult it is to get witnesses to prove the even offences which have taken place in broad daylight in public places, how difficult it is to get witnesses. They will think twice, thrice before squandering a piece of evidence which is already available. The usual argument that there were 100 eyewitnesses, only 2 have been examined, or only 1 has been examined, may not today hold forth. And therefore, you've got to understand that all these put together, Section 3 of the Evidence Act ultimately gives you the answer for appreciation of evidence in a criminal trial, and that it applies to civil trial also. I'm talking about criminal trial. Civil trial, you have greater inputs available. Many a criminal case may have to be decided on the eyewitness account of one witness, may be supported by the FIR or a 161 statement alone. And therefore, appreciation of evidence is a real complex problem of criminal law. And it is good that our search for excellence, our strive for excellence, we fashion our criminal trials in such a way that we are able to get circumstances which we can tell the court and request the court not to accept and act upon such evidence. Thank you very much. I don't think I have a
Yeah. Hello. Am I audible? Hello. Hello.
No. Can you hear me?
Yes, sir. I can hear you now. All right.
See you now. Yeah.
All right. So now, at this point, we will be taking questions. If there are any questions from the audience, you guys can send it using the Q&A option. There's already one question that I'm going to read out. This is this is a question from Biju Raman. Now the question is, what if we, after proceeding with a case, realize that the accused whom we are defending has indeed committed the heinous crime? How do we reconcile this with our conscience? How does a lawyer overcome this dilemma?
All right. He has raised a question which had worried me as a law student. I think I remember where once we called great Justice Nyaya to our college and wanted him to speak on truth and the legal profession cannot go hand in hand. we put this question to him and wanted him to explain. Well, the truth, I've always said, in a criminal trial, it's not the search for truth alone. A lawyer, before he accepts a brief, has to understand that you are accepting the brief so that all available defenses for an accused is made available to him. See, being a lawyer is the duty of the lettered to the unlettered, the knowledgeable to the ones who are ignorant, to the expert to the laity. Well, if he were able to defend it himself, he would have done it. Now, if your question is, supposing I realize that a person has committed a heinous offense, and therefore I think I cannot do my best to him. Well, it's an ethical conflict. Sometimes you realize that, oh, I can't lend my faculties to such a person, and then the best option that you have is to recuse yourself. Well, but I would think, in fairness to the accused, you must do it before that, before you accept the brief. And halfway down the line, if you come across with this statement, it's not discharging your professional duty. It's part of your mission as a lawyer practicing on the criminal side to point out to the court that there is no valid, acceptable evidence against an accused. That is also part of your duty. And when you accept a brief, I believe you totally understand that it's your duty to give him everything that the law provides. In many a case, there will be a confession statement. Well, I believe when we started our practice, the directive to all judges was never read the confession statement. Today, many a judge starts the trial after reading the confession statement. Unfortunate. But then the point is, at that stage, you are not really concerned with what had happened alone. He is entitled to every defense permissible by law, and if a particular fact has not been proved, he is entitled to take advantage of that. Now, otherwise, if search for truth was the only mission, or the civilizational concern was only the search for truth, I don't know why dependable evidence given, confessions given, cannot be accepted. Well, that is the societal finesse, as I called it, in order to eliminate certain other misuse. And he is also entitled for that. Your duty, definitely, is to provide to this unlettered man, or the layman, the non-expert man, the ignorant man, all the benefits which are available to you under law. Available to him under law, which you are bound to. I have no doubt on that. Your subjective assessments of culpability should never stand in the way of that person getting all the benefits of the civilizational law that we have. Well, I can understand Biju Raman, you said it, I think I know him also. I really understand that this problem comes more for a trial lawyer than the Supreme Court lawyer. I find my conscience is very clear. I argue on what is available. I don't worry about the truth because I can't ascertain. I can't ascertain what the truth is at that stage. But at the trial stage, probably the lawyer comes and tells you before, the accused comes and tells you beforehand what will happen. Well, lawyers, criminal lawyers must be made of sterner stuff. If you think you can't do that, please don't accept the brief. But having accepted the brief, don't develop cold feet halfway through and say that now I think you are the accused, you have committed the offense, and therefore I can't defend you. I think it may be professional impropriety to abandon the work halfway through and leave him at a very, very vulnerable situation. I wouldn't advise you to do that. I would always ask you before you accept a brief, if you have such conflicts, you think, and I think I would always think, if I think that I cannot do justice to him, I cannot give full justice to his cause, because I think I'm convinced that he is guilty. My only course open to me is not to accept the brief before I'm engaged. When you are engaged, you take a decision to go ahead or not. Otherwise, you are not living up to expectations from you as a professional. I hope I have tried to clarify your difficulty, Mr. Biju Raman.
Thank you for that answer, sir. Another question from Anurag is, since we have imported certain provisions such as protection against illegal searches from the US Constitution, should courts now look into fruit of a poisonous tree doctrine like the US and start excluding illegally obtained evidence, whether relevant or not?
I believe Indian law is clear on the point that there has been some inadequacies in the procuring of evidence will not by itself vitiate the evidence, and therefore you can look into the evidence. That's the Indian law. Indian law. Should be the fruit of a poisonous tree doctrine, whether it should be applied here, I would personally feel it's not necessary. It's not necessary at all. It's not essential at all to adopt that. If the court is convinced about recovery, notwithstanding the inadequacies, improprieties, and say even illegalities in the procurement of that evidence, I don't think one should squander the evidence that is
available. All right. Another question from Ajay is how the doctrine of preponderance of probability in civil cases came into being. Was it a judge-made doctrine?
very good. Good question by you. I read to you Section 3 of the Evidence Act. Expressions proved, disproved, and not proved. Is there any distinction in the criminal trial and a civil trial so far as these expressions are concerned? Well, you will all agree that these expressions have a common definition insofar as civil case is concerned and the criminal case is concerned. They are not different at all. They are the same. Both in a civil case and a criminal case, identical definition, the same definition applies. But then how come? I have considered this as a judge of the Kerala High Court in some decision. How did this difference come? How did this difference of preponderance of possibilities and probabilities in a civil case and proof beyond reasonable doubt in a criminal case arise? Well, I would certainly feel, I would request you to read that decision of mine if you have time and the inclination. I would think that it means the same. The prudent person standards when you adopt, a prudent person insists on stronger evidence for a graver consequence. Look at your child. The child does some indiscretion. Depending on the indiscretion, you modulate the response. If it is slight, you only chastise him. If it is very serious, you give him a thrash. Well, depending on that, you find, depending on the consequences, you may regulate the you may insist on such evidence that is necessary. A prudent person standard when you import into the definition, this goes without saying. Deprivation of life and liberty, you have read the Indian Supreme Court decision on that, where there is a residual doubt, that is, proof beyond reasonable doubt is still established. It is still there. But then, if then there is a residual doubt, you should not impose the maximum sentence of death. What does that mean? Depending on the consequence, a prudent mind calibrates and decides what evidence should be there. Well, in a case where the consequence is deprivation of life and liberty, a court insists on stronger evidence. And the other one, so far as the civil case is concerned, considering the probabilities, it may be enough. A proof beyond reasonable doubt need not be insisted. This is the only way to do it. Well, at the end of the day, I always felt that the two are not very different except this. The standard of proof in a civil case and the standard of proof in a criminal case are not materially different except that stronger evidence will be insisted when the consequence is graver. Have I explained? Have I been able to explain to you? Well, that is what, and then I also said, I had the time for that, because the proof beyond the shadow of a reasonable doubt, which appeared to be the yardstick by which evidence in a criminal case was measured, is again, if you go through it, judges in their address to the jury are laymen. They are bound to be carried away by emotions. And then the judges always wanted to caution the jury that you have to be very satisfied before you deprive a person of life and liberty. And so the courts started saying, insist on proof beyond doubt. First of all, there must be proof. The expression proved, I already said, is already there. Expression proved. Then you said prove beyond doubt. Now, if there is a doubt, will it fall under proved, disproved, or not proved? Well, the expression proof beyond doubt itself conveys only a caution and not anything different in substance. Well, the address to the juries, the judges have always been saying, oh jury, who are this jury? Laymen who may be swayed, and therefore they are told, don't get swayed, insist on good proof. And so they said, insist on proof beyond doubt. Now they thought even that is not sufficient. The lay jury was getting carried away by emotions, and therefore they wanted to tell the jury, oh jury, insist on proof beyond doubt, insist on proof beyond reasonable doubt. I have never been able to understand this concept. Now, can there be a doubt which is not reasonable, which continues to be a doubt? Have I made myself clear? Can I say, I have a doubt, but not a very reasonable one? Well, that is not. Well, it is only a caution administered to the jury, which we later on thought was the inflexible law. The law which said insist on proof was sufficient. If there is no good proof, it would have fallen either under disproved or under not proved. Now, once you come within proved, you also say insist on proof beyond doubt. That is a caution administered to the jury. And then the jury which does not understand this also, you say, jury, please insist on proof beyond reasonable doubt. As though there could be a doubt which is not reasonable, which could qualify to be a doubt. And then they said, insist on proof beyond the shadow of a reasonable doubt. Now, if there is no doubt, there can be no shadow. If there is no reasonable doubt, there cannot be a shadow of a reasonable doubt. First of all, there must be the object in order to have the shadow. We have, according to me, thought that there is a mysticism or a magic in the proof in a criminal case. Well, I think it's very pure and simple. You have to insist on proof. Doing that, how did the difference between civil and criminal cases proof come? Because of the consequence, you always make sure that you have adequate evidence. You are sure even a residual doubt would qualify to avoid a death sentence. Well, it is in that area alone that this would apply. Not that proof beyond the shadow of a reasonable doubt and proof are so very different at all. Not at all. The prudent person standards when accepted, the prudent person would insist on stronger evidence for more disastrous consequences. And that's all. Deprivation of life and liberty, any prudent person will insist on a better, more sure proof than a mere civil. Well, that's my opinion. They're not different substantially, except depending upon the consequence, some stricter evidence may be insisted in a criminal case.
All right, thank you, sir. So we have a lot of questions left. We could maybe perhaps forward these questions and have them answered by email. But sir, if you are okay with answering another 2 questions, would that be okay?
You absolutely no problem at all. I have time, so you can. Well, one good thing about the lockdown is everyone has ample time, and therefore I'm not worried. You can go ahead.
All right, thank you, sir. So Adil Mushtaq is asking, the influence of media over this system is increasing day by day. Bar and bench both susceptible to this influence. Is a danger to this is a danger to the concept of fair trial. Do we need a mechanism to ensure this influence does not penetrate courtrooms?
Well, a very, very good question. Very good question. You know, the media trials that take place. When I started practice in 1973, if somebody had asked this question, I would have considered it blasphemous. A judge being influenced by the media trial that takes place. I always thought my judges were made of sterner stuff, that they would not in any way be influenced by the media trial. I thought they have the inner strength to ignore the media trial. I never thought that they would be populist to toe the line of the media and to render judgments on the basis of media's assessment. In every class in the academy, I tell my junior judge friends, do not be influenced by media trial at all. You are not to be to be influenced by the media propaganda. A judge must have the strength of character. He must be made of sterner stuff, that he will look at evidence on the law and not the daily newspaper. I have a problem today. Judges vertically are looking at tomorrow's headlines in the newspapers before they render judgments. Well, I'm worried about that. Well, that's the antithesis of rule of law. If you start giving 1 year to the media headlines, the channel discussions that take place, and then you start writing judgments, it is the antithesis of rule of law. I have no doubt on that. Both the lawyer and the judge must be able to transform themselves to a level that they are not influenced by the media trial at all. Is it possible? You may accuse me, you are pontifying. But is it possible in today's atmosphere to do it? I would think my judges must be strong enough to do that even now. That is the glory of the judicial office. Well, that is what I would like them to be. If there are judiciary is not a monolith, sir. Not a monolith. It is made up of different parts. Somewhere somebody is getting influenced. We should inspire judges to be uninfluenced by the media trial. Well, I see that. Not that your question is irrelevant. I find quite a lot of cases today, rightly or wrongly, media attempts to, and in some cases get successful in influencing the decision. I remember when Kasab was Kasab's sentence was to be pronounced, the media was giving 49,29,000 so so people in favor of hanging, 3 persons against. This is one subtle way of attempting to influence the media. Whatever the judgment, I think the judgment of the judge, the court must be its own and not of anyone else. Not to be influenced by anyone else except the law and the facts and the evidence. Well, I can see your concern. This concern is increasing, sir. I am conscious of that. We need judges who are able to ignore, totally dissociate themselves with the media hype that is created and be able to look at evidence and the law only. I hope we have more and more of such judges and less of those of the other variety who, according to me, do not qualify to be called judges at all. You shouldn't be. Now, is it possible? Yes, it must be possible. It is only such persons that must come to the judicial office. It's not for the other. It's not for the ordinary. Judicial office must be there for the ones who are able to fight themselves, fight the prejudices themselves, fight the media influences themselves within them, and come out with verdicts on law and fact. Well, I really worry about today's generation, which has to really worry about that sort of possibilities, which at a certain point of time was not there at all. Very good. Well, today is very different. It's a very different ballgame today. And so I understand what the apprehension that you express. When I started practice, the type of allegations that are today being raised against raised against an ordinary low level, the grassroots level functionary of a municipal or a magistrate. We have come to that. We have come to that pass, and which is very unfortunate. Which is very unfortunate, and that is why putting questions like very good. I feel very, very strongly that judges should never be in any way even remotely be influenced by the media trial. Ideally, yes. Then.
So the next question is regarding technology in the courtrooms. So data protection laws are based on the IT Act. What will be the challenges at the time of adducing and appreciating evidence? Furthermore, there's just been a lot of changes that technology has brought into the courtroom, and it's made courts and arbitrations very maybe overly technical at times, with several expert witnesses being brought in. How would lawyers and judges who are not familiar with such technical details start interacting or dealing with these increasing technicalities? Thank you.
Very good. I understand the question. Well, a lawyer was always supposed to be the master of all the branches of knowledge. He was supposed to be competent to study those branches and bring himself up. The development in science, technology, the knowledge as such is so vast today that the shall I call it the myth that the judge is the expert of experts may be soon vanishing, or it continues to remain only a jargon. But the fact and conflict means somebody to resolve it, and that resolution will have to be done by the judge himself. Maybe judges will have to become more and more competent to deal with such situations. Maybe the lawyer who I remember in my young days as a lawyer, in a Prevention of Adulteration Act case, an expert had to be cross-examined. My senior got my chemistry professor, and he tried to learn it, every point he tried to learn it, and then went on to cross-examine the witness. But then he was not very sure. He took the permission of the court and got this expert to sit by him when he cross-examined. Well, that's it. That's it. If you are not able to update yourself to the requisite level of technological and scientific competence, you will be thrown to the dustbin of history. If I can't, I found it very difficult to operate this. And I was always thinking that the near is the date when I'm going to be outdated. Because, all these adjustments, this, that, etc. I'm fine. I have to learn. And 69 years, 70 years is too late a period to learn for most of us. But then the problem is, if you're not able to see, supposing I say, I go to the Supreme Court because I'm not very conversant with video conferencing technology, I will not hear. And the client is going to somebody else. And therefore, there's a compulsion on the legal profession and the judges who stand to the legal profession to update themselves technologically and scientifically. And therefore, I don't think there's going to be any problem. All the lawyers and judges will get themselves technologically updated, improved, and be able to deal with the situation. Those who are not able to will be thrown out. If I'm not able to do it technology, I will definitely say, sorry, it's not my. How many lawyers have gone out of the profession like that? Not able to update themselves, not able to adapt themselves. I remember in my court, I'm from the Calicut court. Sessions case used to be argued at least for 3 days. Now, if somebody is there to try that now, you know what the consequence would be. Well, it has become condensed. It has become very matter of fact. It has become, the verbiage has gone. And the technology, that's one thing that I find very useful in technology. Those who are outshout others will go now. Those who wield the court or they dominate over the court will not be able to do that. And in that view of the matter, will this be good or bad for the system? I think there are a lot of good. Of course, traditionalists like me, who always depends upon how the judge reacts to an argument, whether he will accept it or not, whether I should take this route or this route to get to zero in on him, we may find it difficult. But then the young lawyers will certainly be able to do that through technology also. I may not be able to do it, but somebody else may be able to do it. Or I may have to update myself to be able to do that. And otherwise, you will be outdated. You will not be there. You will not be in the fiercely competitive profession of law. You will not be there. That is all. The system will move on still. Well, it is true. The concept of openness of courts is not strictly confined to the brick and mortar. Openness can be achieved even by not being personally present in the age of the pandemic. It must be possible. But of course, live streaming may have to take place if we have to resort to video conferencing in all cases, certainly, because the concept of courts being open will be defeated if we have only parties to the cases being heard and for the rest of the world that being obscure. Well, that is not the alternative. Live streaming, if it takes place, you need not be in the courtroom to do lawyering. It can still be open. I would agree, but then provided the live streaming is there and anyone. Even today's courts, are they really open? Even today's courts, tell me, are they really open? Law says anyone who wants to come in can come and take part or listen to the proceedings in an open court. But today we don't have the infrastructure to permit everyone. So what do? We give accredited representatives of the press to come there. They will report to the world what has happened here. And similarly, if live streaming takes place, where is the argument of opaqueness? Well, the pandemic is going to change the world. As someone said, see, it may later on be said that time may be divided into before COVID and after COVID. And therefore, it's very possible that all that we are used to, we are accustomed to, may change even in the legal system. But then that by itself is not disastrous. No, you can maintain the elements of openness and still be able to borrow technology for expeditious disposal of cases. I don't think the idea is negative at all, provided we take safeguards. Okay, then.
So, the next question is, post the Verma Committee report leading to the criminal law amendment, how does an advocate reconcile the gap between principle of corroboration of evidence with the amendment doing away with the requirement for said corroboration?
Well, corroboration has never been a rule. It has been only one of caution. Well, there is no law which says that corroboration is necessary for all types of evidence. It was not there at all. It was not there at all. And therefore, to dispensing with corroboration, if the legislature finds that the insistence on corroboration, ritualistic insistence on corroboration is leading to injustice, I don't think there's anything wrong in the legislature prescribing that corroboration cannot be implemented as a matter of rule or law. It's only one of prudence. It's only one of prudence. And therefore, dispensing with the requirement of corroboration in all cases may not necessarily lead to injustice, provided the judge is good in the appreciation of the uncorroborated evidence.
All right, sir. So since there are a lot of questions, we might email some of them to you, sir, and we will address some of the questions in our blog post. But for now, we would like to thank you for taking this time out of your schedule to address all of students.
Yeah,
And
just one line also. That
yes,
Viju Raman's question does in a way disturb me, because I think I to him a little more. Well, I think when we all became lawyers, my senior used to tell us a story. He told us that never lose a case, first thing. Well, that is a little odd. How can I ensure that never lose a case? All that he meant was never lose a case for want of preparation by you. Everything possible to be looked up, and then therefore you try never to lose a case for your under preparation. And he said, you may lose a case, but never lose the client. Which means, in spite of your preparation, you may lose the case, but you have got to make sure that the client understands that you are prepared well, you have done everything possible for him. You may lose the case, but do not lose the client. And the third one that was said was, you may lose the case and the client, but do not lose the judge. Not that you have to butter him. That's not what was meant. What was meant was, adhere to your principles so steadfast that you do not misrepresent a fact in court, you do not mislead a court, you do not do things unethical in a court, and therefore never lose a court. And finally, the fourth one, he said, you may lose a case, you may lose a client, you may lose the court also, but never lose yourself. Well, Mr. Viju Raman, who put that question, I would tell him that if you think you're losing yourself in the battle, kindly do not accept the brief. But I would still think that there is a place for people of that temperament. I want such men and women to be attracted to the judiciary. It is they who can serve the judiciary best than the people, those who have crisis in their conscience, and they think that their idealism does not help, does not permit them to do certain things. I believe that they are really judge stuff. They are really persons who have idealism in them, and therefore I would certainly expect judiciary to be filled by persons not by seekers of power, not by seekers of position, not by seekers of salary and allowances, but by men who have conscience and idealism like that. And that is what I